Good morning.
Good morning, Your Honor. May it please the Court, my name is Bill Narwald. I represent the plaintiffs' appellants, Thomas O'Connor, Patricia Gatto, who are the current trustees of 3 Redstone family trusts, and Michael Redstone, one of the beneficiaries of those 3 trusts. We have raised 4 independent grounds on this appeal on which we believe the judgment of the trial court should be reversed. First, we've argued that the trial court erred in rejecting the actual knowledge of the beneficiary standard that this court has laid out for over 150 years and applying instead a constructive knowledge of an interim trustee. Second, we argue that the trial court erred in not even considering our argument regarding the appointment of a guardian ad litem either in 1972 or in 1984. Both of these self-dealing redemption transactions involved minor, missing, unascertained, and unborn beneficiaries.
The 1972 transaction just seems very different than the 1984. That's not a redemption at all, is it?
It is a redemption in this sense, Your Honor, that in 1972, there were 16 2/3 shares held in trust for Ruth Ann and Michael, which Edward used to resolve his dispute with Sumner.
I thought there was no trust agreement.
There was.
There was a written trust agreement?
There was not a written agreement. There was a 1959 oral agreement, which is referenced in the written trust agreement.
Disputed. I thought this was a disputed.
Yes, but it's summary judgment, so you would say we have to accept that it's there.
It is on summary judgment, but we can say it's disputed, but the document, the 72 trust document, the actual memorialization document, says right in it in the first paragraph, this is a memorialization of a previously existing oral trust. The settlement agreement, which was done in 1972, which is part of this record, references those oral trusts that were established at the time the company was set up in 1959. So I don't think it's disputed that there was an oral trust. The only documents we have both reference this as pre-existing oral trust.
I think it may be disputed.
Yeah, I mean, I'm
But-
very
but-
confused.
but
I won't hold you up on that.
But the point being that the documentary record is that there is a clear reference to that. When Mr. Edward Redstone signs the release in 1972, he does so as trustee for his children. So I think, in any event, we're on summary judgment. Even if it's a contested issue, there's certainly very substantial evidence that there is pre-existing oral trust. The third ground for basis on our appeal is...
Excuse me. The other side argues that your argument that the statute of limitations doesn't start in the trust until actual knowledge of the beneficiaries would mean that the statute of limitations would never run in the trust context, since newly born beneficiaries could always revive by lapsed claims. How do you argue that? By saying that a guardian ad litem would suffice?
I have a couple of responses to that, Your Honor. And number one, this rule's been in place for almost 150 years, and we haven't seen the sort of parade of horrible arguments. Number two, both of these transactions are self-dealing transactions. That is, that you have Sumner as sort of buyer and seller in both of these transactions. In those circumstances, what you do is you appoint a guardian ad litem, you have full disclosure to the beneficiaries, and where you have
but what about if there's nothing in court? How does the guardian ad litem get appointed?
Well, that's the whole point, Your Honor. In this circumstance, there should have been an application. In 1972, you have 2 minor children, one of whom is institutionalized. In 1984, you have a daughter who has been missing for a number of years, a primary beneficiary under all 3 of these trusts, and no one seeks application. Why do they not seek application? Because they don't want court review of this process. But let me get to the final point on the issue of the statute of limitations never running. There are 2 different arguments here. There's a statute of limitations argument, which all the trial court dealt with. You also have, in an equitable action, such as a breach of fiduciary duty claim, you have the doctrine of laches, which has been pled as a defense in this case by the defendants. And so while the statute of limitations does not have a repose piece to it, certainly a trial court, as in an equitable proceeding, can look, for example, Justice Cowan, in your suggestion of successive generations, could look and decide whether the harm and the prejudice here were at a point where 3 generations later because of the loss of documents, loss of witnesses, and so on, that it might be appropriate to apply the doctrine of latches. So I don't believe that you have a situation where this is totally open-ended. And the real answer here, it seems to me, Your Honor, when you weigh this, and I think the reason we have the rule we have in Doe and Latuca, Demoulas, and going all the way back into the 1800s with these cases, is that the relationship of a trustee to a beneficiary is one of the most sacred relationships that this court recognizes. And when you don't have full disclosure and when you have self-dealing, the notion that this can be raised years later is not an offensive notion, because typically the beneficiary is relying and placing trust in the trustee. And so the notion that this happens many years later should not be a problem. And if I look at Demoulas, I mean, we keep hearing that this transaction, the 84 transaction, occurred 22 years ago. In this court, in 1997, this court said in Demoulas, we'll reach back 19 years. The issue in Demoulas is very similar to what we have here, Your Honor.
But you, I guess I have two questions. One, you say Demoulas is similar, but you also seem to make the argument that when the defendants use the language in Demoulas about somebody who isn't involved in the wrongdoing, you say, oh no, that's a corporation, this is something different.
There are two different decisions in Demoulas, Your Honor. There is, and I know Your Honor is aware of that, there is the stock transfer case and there's the derivative case. In the derivative case, there is a discussion of when the statute of limitations runs. And if you read that entire paragraph in context, what this court says is, first, there's two parts to this. It says the
Is the
knowledge
derivative
of the
424, or is that the stock transfer? Do you know?
I'd have to look at the pages, Your Honor. They follow one another. But the discussion occurs, and this court says, we're going to look at the knowledge of the beneficiary. It then goes on to say, another basis for looking at statute of limitations in this case is that in a derivative case, a corporation, we are going to look at when there are disinterested directors that come into the corporation who can bring the cause of action. And so all we're really saying in that point, Your Honor, is that what the trial court did and what the defendants have argued is you can substitute the word trust for corporation. And I think they're entirely different animals when you're looking at what's in the situation of a corporate director acting on behalf of a corporation. You don't have the same relationship of a trustee to a beneficiary. And what I think this court was saying is that when a corporation finally gets to a point where it has disinterested directors, it can go ahead and act at that point. It's very different than the beneficiary who never has knowledge. And that's our point, Your Honor.
Could I
But
just-
here you have the trustee, Mr. DiGiacomo, after March, I think beginning March 9th of 1984.
In two of the trusts.
Yeah. He had knowledge of the three documents that you claim were essential to your case, to your claim. The 1972 settlement agreement, the Rosen report, and the 1984 settlement agreement, or the 1984 redemption agreement. He had knowledge of those, and he made a conscious decision not to bring a lawsuit against the defendants in this case. Didn't the statute of limitations run on that claim?
No, Your Honor, for two reasons. One is we don't rely just on those three documents. That's the defendant's argument. That's not our argument. I mean, if you look at the sworn interrogatory answers, which were part of the record here, we talk about not only those three documents. We talk about the deposition of Edward Redstone in the 2004 litigation. We talk about the deposition of Attorney DiGiacomo in the 2004 litigation.
Yes, you talk about those, but isn't, and I read that in your reply brief, but isn't that knowledge, isn't having knowledge of those three documents sufficient? You don't have to know every single thing.
No, what you need to know is, Your Honor, not that those documents exist, but that the beneficiary has been harmed. And when I had deposed Attorney DiGiacomo in this case, I said to him, both as to Sumner and Edward, and we quote this in the brief, did you believe, or did you ever believe at any time, that there was anything that either Sumner or Edward did that was in any way inappropriate,
No,
wrong?
he said no.
And he said absolutely not. He did not. This is not a situation where a trustee knows and makes a conscious decision not to bring a claim. We don't have the situation where he says, look, I know there's this claim, but I'm going to do a cost-benefit analysis and not bring the claim. He claims he never knew to this day that there was the basis for a claim. And if you think about it, it makes sense. I mean, if he couldn't be involved in the transaction, then turn around the following day and say that the transaction I've just been involved with for the last year was infected in some fashion.
So what did Mr. Redstone say that's so important in this case?
What Mr. Edward Redstone said in 2004 were a couple of things. He elucidated on what happened in the 1972 transaction, which is that He had no knowledge of what the document said. He signed whatever was put in front of him, and what we got were all of these documents whereby he abdicated his responsibility as trustee to his own children, allowed these shares to be redeemed, and was using the children's share to settle the dispute with Sumner. And what he said is, look, I was upset, I was emotionally distraught, I signed whatever documents they put in front of me, and what he did is he
Was
signed
he
it.
represented by counsel? Was Edward Redstone?
He was represented by Mr. DiGiacomo in 1972. So, this whole issue and it gets into this whole issue of conflict. You have a situation in 1972 where Attorney DiGiacomo is Edward Redstone's lawyer, who is, in our view, extracting 16 shares from the Children's Trust. So when you get to 1984, Justice Mann, you talk about, well, didn't he bring a claim? He really couldn't have. And this is our argument, of course, on the issue of, he was conflicted in this situation. But I come back to the basic issue with Mr. DiGiacomo, which is that it is our view that he was misled just as the beneficiaries were misled, which is the issue is not these three documents. The face of these three documents don't tell you anything. What they tell you is there was a settlement in 1972, there was a redemption in 1984. The issue is the fairness of those transactions. And if we look at 1984, what's missing, and what I showed Mr. DiGiacomo, was current financial information of NAI, of National Amusements. And I said to him, did you have this information? No, I didn't. And our point is that he didn't have the requisite information.
Which financial information? You're talking about the 1984 statements that he clearly wouldn't have had?
The 1983 statement, Your Honor.
Right. And he said he never had that information?
He did not have that information.
I thought his testimony was that he basically got whatever he requested and would have requested all of the financial information that would have been relevant to
He said that, but as to this specific document, he did not. And in fact...
This is 23 years later. I don't remember seeing this particular document.
But there is more to this than that, Your Honor, because in the proceedings in the trial court below, and this is not disputed, we had to move essentially to get those documents because we were told that they did not want to produce any documents that had not been provided to Mr. DiGiacomo at the time. And so I don't think and his testimony I acknowledge is many years later, but I don't think there's any question that he did not have that information. And when you look at that information and you see over $300 million of stock and real estate, and you realize that 45% of this company was sold for $17 million.
So the 300, that's net, or is that just assets, not discounting liabilities?
On the securities, Your Honor, there was approximately $90 million of margin against $175 million of total securities. On the real estate, at cost, the number is approximately $175 million. The debt is fairly modest. I can't tell you the exact number. I'm going to say it's less than $50 million because a lot of this real estate was acquired very early on. Our point being, and this point is made in the expert affidavit, which is in the record, which is if in 1984 you had given zero value to this corporation, you had given zero value to the real estate, and all you did was to value the cash and the marketable securities, less any debt. That's all you did. You just looked at cash. That the valuation that was ultimately arrived at is still 3 times below where it should have been. That is, there was $100 million of cash and marketable securities, net of the debt, net of everything else, and this is in our expert report that's in there, so that even if that's all you were valuing, that's where you are. And Attorney DiGiacomo did not understand that and did not know that and did not appreciate that. In fact, he was told at the time, and there's not, his testimony on this is quite clear, is that the $15 million paid over 10 years with an unsecured note at a below-market interest rate might break the company. That is, that it was so much that it was a question of whether they could actually afford to pay the amount. And so,
in today's dollars, how much are you arguing over in this lawsuit if you win?
if we are correct, Your Honor, that either rescissionary relief or rescissionary damages is appropriate, we don't know because NAI is a privately held company, but I believe the number to be in the billions of dollars.
Billions.
That's on a rescissionary basis.
On a rescission basis. If you were to look at a different basis, which is the difference between what they got at the time and what fair value would have been at the time, which this court in Demula said you look at fair value, the number that is at least in the expert report that we've got, which is based on the Rosen methodology, is something in the neighborhood of $70 million differential at the time. So depending on the measure of damages you look at, that's what we're...
I thought the Rosen methodology was rejected because it was too low. So the Rosen methodology didn't play any role at the end of the day in valuing this company.
I don't think that's accurate, Your Honor. If you look at the 1984 settlement, the redemption agreement, if you look at the whereas clauses in there, it specifically states that the valuation is based on what it's called the detailed valuation of Mr. Rosen.
But I thought
but
that
it's like-
detailed valuation was below $10 million.
It's
which
like,
was
yeah,
rejected.
9 million versus 21 million or something like
Now,
that.
let's go through the numbers. I think they're important. Initially, they were going to redeem 58 1/3 shares, and he valued 58 1/3 shares. He valued that at $9.8 million, those 58
The
1/3.
second time around.
Second time around, a month later with the more current data. The ultimate purchase price is about 21 paid over time, but that's for 83 1/3 shares. In other words, now they've added Brent and Sherry's shares in there as well. And so you can't compare the 9 to the 21. You need to compare the 9 to the 15. It's because they added 25 more shares. But here's the important point about the 9, and here's the issue that I think what you're going to see is that, in fact, the Rosen valuation comes in spot on, which is this. The Rosen valuation to get to the 9.8 million takes a 35% discount for lack of marketability. If you put that 35% back in, you get exactly to the $15 million. What this court said in Demoulas was where the trustee initiates the transaction and the trustee is benefiting by an increase in his shares, you cannot use a discounted value. You must use fair value, which is exactly what the issue was in the Demoulas stack transfer case. So, in fact, what happens here is that where Attorney DiGiacomo ends up at the end of the day is actually worse than where Rosen was, because Rosen is really at $15 million when you take away the 35%. Attorney DiGiacomo negotiates $15 million paid over 10 years at a below-market interest rate, which our expert says is about $12 million.
You don't contest, though, that your client, well, Michael Redstone and Brent and Sherry were pushing hard to have this redemption happen in '84. Isn't that so?
I do contest that, Your Honor, and that's certainly contested on the record. And let me talk about that. As to Brent and Sherry, there was zero evidence on the record other than the one document signed at the closing. As to Michael, and remember for the moment, that Ruth Ann is missing altogether, so we have nothing on Ruth Ann. And so, but Michael, the evidence I think is pretty clear that Sumner initiated this. There is no question at some point that Michael was certainly anxious to have it, continue and occur. But that is not, to me, it is not an issue that matters here, because the fact that he wants it to happen, or any of them want it to happen, doesn't allow you to then say, well, because of that, we're going to overlook if there's some unfairness in the transaction. The urging is really not, and we cite this in our reply brief, Your Honor. I want to be clear about this because I think it's an important point, which is that this document that gets signed on March 8, which the urge adopt an approved document, to make that document effective, three things have to happen. One, it has to be based on full disclosure. The cases here are clear on that.
Why? No, I'm not going to. I'm not going to stop you. But Mr. Nowell, full disclosure, yes. But who had the obligation to ask for the full? You say.
It's not an ask obligation, Your Honor. It is an obligation of the trustee to have the beneficiary be as informed as the trustee is about the facts. That is an obligation imposed on Sumner Redstone to say, look, I am transforming this company. Look, I have $175 million in securities. Look, here's where I plan to go with this company over the next couple of years. I'm going to roll up all these the trustee has to tell the beneficiary this. That's one, full disclosure. Two, it has to be consent of all the beneficiaries. And here we don't have Ruth Ann, and we don't have any of the minor and missing.
Does the 1972 agreement specify the number of shares that the beneficiaries had?
No, it does not, Your Honor. What it says is that the settlor, Mickey, the grandfather, had always said that at least 50% of the shares were held in trust for the children. Edward says, I agree that a certain number were held in trust for the children. I disagree about the amount.
And Mickey participated in the 1972 settlement,
Correct, Your
which resulted in less than 50 shares going to the children, to the
That is correct,
beneficiaries.
Your Honor. Yes,
Okay.
and I think that for summary judgment purposes, we've got a contested issue there as to whether Mickey, in the notion of sort of family harmony, says, I'm going to figure this all out and allow Edward to continue to assert, because Edward was asserting ownership to all 100.
Mr. Nowell, you can make just very briefly your third point about why the urgent adoption.
Yeah, let me finish that, and then I will close, Your Honor. Appreciate your indulgence.
That will
the
be
third
your
point on
close.
on the urgent adopt document is that, and this court's cases in Schur and in Atkinsburg versus Warner, is that the transaction must be objectively fair and reasonable. So if transaction is not fair, having a document that says I approve it doesn't make it fair. Let me close, Your Honor, with this, and just to affirm the judgment of the trial court, this court has to do four things. It has to accept the argument of the trial court that we're going to abandon the actual knowledge of the beneficiary standard. You have to find that Attorney DiGiacomo, under that kind of a regime, knew and elected not to bring claims, and the evidence is exactly to the contrary. You have to find that despite the fact that Mr. DiGiacomo was not a trustee of the 68 trust, that he could still somehow bring claims on behalf of that trust. And you have to really disregard the GAL statute because we have minors missing in both transactions. And for those reasons, Your Honor, we believe that the judgment should be reversed.
Thank you, Mr. Narwold. Mr. Keating?
May it please the Court, my name is Michael Keating, and I represent Sumner Redstone and National Amusements, Incorporated. I'd like to begin by talking about the role that James DiGiacomo played in this particular case because it's critical to the statute of limitations standard that we believe applies and the standard that the trial court applied. The 1972 agreements had an unusual provision which stated that an independent counsel would be appointed to assure that the stock which was redeemed from the beneficiaries would be redeemed for a fair price. Mr. DiGiacomo, who had familiarity with the family history in this particular case, was appointed by Mr. Redstone, who was the trustee of the 72 trusts, to be that independent counsel. The record in this case is clear that for over a year and a half, Mr. DiGiacomo faithfully, diligently, and thoroughly made efforts to correctly assess the value of the stock. He engaged outside experts from Citibank. He rejected, as Justice Cordy pointed out, the valuation put forth by Mr. Rosen. Ultimately, he achieved for the beneficiaries twice what Mr. Rosen originally thought the stock was worth.
But was it for more shares? Was it for more shares, though? Was it for more shares
No,
than Mr. Rosen?
I think for the shares that actually went to Michael and to Ruth Ann. I think Mr. Rosen's original valuation was around 7, and it ultimately turned out to be 15, according to the redemption of just Michael and Ruth Ann shares. He consistently fought with Sumner Redstone throughout the year and a half. Sumner Redstone was very impatient with how long this was taking. He rejected Sumner Redstone's views of what the stock was worth, relying on the opinions of Citibank and the experts he retained, and he even threatened to bring Mr. Redstone into the probate court when Mr. Redstone indicated that he might not go forward with the redemption. Now, why is that important? It's important because Mr. DiGiacomo thereafter became the trustee of the 1972 trusts. And by virtue of his performance throughout the period of the redemption, I think it establishes two things. Number one, he had great familiarity with the whole transaction involving the 84 redemption. But more importantly, it reflected an independence of mind of Mr. DiGiacomo when he approached his responsibilities as the trustee of the 1972 trust, which he assumed in 1984. And that, excuse me, Your Honor.
No, you finish.
And that becomes critical to the relevant statute of limitations issue that's presented in this case. Mr. DiGiacomo was under the Demoulas case when he became the trustee of the 72 Trust in 1884, and he continued to be until 1992. He was invested under the Demoulas decision with the power and responsibility to act on behalf of the trust and on behalf of the beneficiaries.
Mr. Keating, let me ask you this, though. Mr. Redstone also remained a co-trustee?
No, he did not. He resigned.
So he was, so...
It became Mr. DiGiacomo and Mr. Rosen who became the trustees following SJC-10080.
Could I just ask you this? Because Mr. Marlowe argued that if one assumes he was an independent trustee, and I know that's another issue, but assume he's an independent trustee, there's a difference between having knowledge and not thinking that there's any basis to bring a suit, and having knowledge, knowing there's a basis to bring a suit, and deciding not to do so.
Right. I understand. I heard Mr. Narwhal. The only thing I can say in response to that, Your Honor, is the following. Although the plaintiffs would like to walk away from the three documents that in paragraph 76 and 77 said they put them on notice, the 72 trust, the 84 redemption, and the Rosen report. They actually can't walk away from those because they say in their unverified complaint that those were the three documents that put them on notice that they had a claim. And those are the three documents of which Mr. DiGiacomo was intimately familiar.
Didn't they also say the discovery in the new suit I think in Maryland or something?
Delaware.
That also gave them information,
But
not just those.
They do, Your Honor, but let me suggest to the court, they have the burden of proof as to why the 3-year statute of limitations shouldn't apply here. They refer to a suit that Brent Redstone brought in Delaware, which was a claim against National Amusements that involved a charge that his father had breached fiduciary duties. They never tell us why that particular complaint, which was ultimately settled, put them on notice of some facts that they otherwise would not have known. And it's our view in this case that by pinpointing those three documents in their complaint and stating that those were the documents that put them on notice, they have put themselves in a position where they cannot deny that Mr. DiGiacomo had that very same information in his hands between 1984 and 1992 when he declined to pursue any claim against the prior trustees.
But didn't Mr. Narwhal this morning say, yes, he had the documents, but he didn't know the financial worth of the company?
As Justice Cordy asked, and Mr. DiGiacomo testified without contradiction, every document he requested from National Amusements or Sumner Redstone was provided to him. Every document which Citibank suggested he request from National Amusements or Sumner Redstone was provided to him.
Mr. Keating, excuse me for interrupting. You heard me ask Mr. Narwhal at the end about whose burden it was, and his position is, as I understood it, he didn't use these words, it was Sumner Redstone's burden to fully disclose. Your position is, Mr. DiGiacomo, I'm now talking about before Mr. DiGiacomo became the 1984 trustee. So when he's acting as, quote, independent counsel,
right,
correct? And he's asking for documents, and Citigroup is saying these are the documents that you can ask for.
Right.
As I understood Mr. Narwhal's argument, and I may get this wrong, he was saying, notwithstanding that, it was the obligation on Sumner Redstone to, quote, fully disclose, as I understood
I understood.
his plans, his
Right.
future plans, and so on and so forth.
Well, I think we may be confusing, in all due respect to Mr. Narwhal, two things. On the issue of the statute of limitations,
No, I understand.
the burden is clearly on them.
I understand that.
On the issue of the fairness of the transaction, I would concede that it's important that Mr. Redstone, as a trustee, be able to ensure that the transaction is fair. But truthfully, I don't think you're at that point, because you've first got to get over the statute of limitations hurdle here. And the statute of limitations hurdle, I think, is fatal to the plaintiff's claim here, because if you accept that Demoulas was first discussed in the context of trusts, as I think Justice Graney did when he wrote the opinion, and that is applicable, although Demoulas was a shareholder derivative suit, the Demoulas standard is applicable here, then you cannot avoid the fact that for 5 or 6 years, Mr. DiGiacomo was in a position to bring a claim. He had full knowledge of everything that went on through that redemption process, and he declined to do so. And that has to begin the running of the statute of limitations under the Demoulas case.
But do we know whether he had full knowledge? We know that he had those 3 documents, and we know that anything he wanted, he got.
Correct.
And that he asked for a lot of documents, but we don't really know, simply perhaps because that's the reason for the statute of limitations, because so much time has passed, whether he had everything he needed to know.
He believed, Justice Cowan, he had everything he needed. And if you read his testimony about how he approached the seriousness of his role as independent counsel, and as this court knows, Mr. DiGiaco is a man of significant reputation and stature in the area of trusts and guardian and litem and whatever. If you read his deposition and you read the thoroughness with which he attacked this problem, and as I said earlier, the way he fought, frankly, for the rights of the beneficiaries on the valuation, I think you'd have to assume, though it's 30-some years ago, that he knew everything that he wanted to know.
Mr. Keating, can I... Forgive me, this may seem so obvious because you're so familiar with it, but I want to make sure I understand
Right,
you.
Your
Mr. DiGiacomo had two hats. Leave aside self-dealing. If I'm not, he had two hats, right? One was of independent counsel.
Correct.
Correct. And that ran from when to when?
It was 1982 to 84.
Until March of 8 of 84.
Correct.
Right? Then March of 84, he puts on a different hat.
He puts on the trustee hat.
Okay. You keep saying when he had a trustee, when he has his trustee hat on,
Correct.
he was very well familiar with, fully informed, that's my word, he was intimately familiar with the whole set of transactions that led, don't worry about that, led to the March 8th, what predated March 8th.
Yes, Your Honor.
If what happened on March 8th was not fair,
Correct.
because let's assume that Mr. Sumner Redstone had the obligation to fully disclose, notwithstanding
Right.
what Mr. DiGiacomo fought
Right.
for, notwithstanding what Citibank told him to
Right.
ask for,
Right.
but there was something else that
Right.
made the transaction
Yeah.
fundamentally unfair.
Right.
Doesn't that carry into the period of time when he was wearing his trustee hat? In other words, what does he gain post-March 8th?
Well, he gains the position of being a trustee so that he has an obligation to assert a claim if he believes there's a claim.
But
that's not
let's
responsive.
assuming that he got what, I think that's the import of Justice Cowan's question. He got what he asked for, but what he asked for didn't establish the fairness of the transaction that led to his becoming a trustee. So
Well,
now he's
I'm
acting
not-
on the same basis of ignorance.
He believed it established the fairness of the transaction. In other words, if you look at Mr. DiGiacomo's testimony, he would say, I was fully satisfied based on my requests and the documents which were furnished to me over a year and a half by National Amusements and Sumner Redstone. I was fully satisfied that
he
it was
believed
fair.
that, but that's why it goes to where the burden is. Let's just assume, okay, there are 5 pieces of information. One, just this is hypothetical, to ascertain whether the thing was whether the redemption was fair.
Right.
And he asks for number 1. There's a big fight. He gets number 1. Citibank says ask for number 2. Another big fight. He gets it. He and Citibank ask for number 3 and 4. But there's a big gap that they don't ask for that really would give a different, which would have a
Right.
substantial impact. He doesn't ask for it because he doesn't know. I mean,
Right.
he's doing the best that he can.
Right, right.
But if the burden is on Sumner Redstone to disclose 5 and he doesn't, now DiGiacomo is going into post-March 8th,
Right.
1984, assuming that he's got everything, but
Right.
he hasn't got the 5th
Right.
pool of data. That's my
Understand.
question.
Right. Well, I mean, I think...
And how
the-
that impacts on on the statute of limitations.
Right. Well, let me answer it in 2 ways. The less satisfactory answer is I think this is what happens in a lot of cases, and the statute still runs. In other words, nobody can know everything. We have to have statutes of limitations, or we have cases like this one where the events are 30 years in the past. But more to the point of this case, Your Honor, I focus once again on what the plaintiffs themselves said put them on notice. I focus again on those 3 documents. And they haven't told us really anything about anything else that would put them on notice. They believe those 3 documents put them on notice. Those 3 documents, now I'm moving away from your hypothetical because I think that's the real case here. We suggest we're so well known by Mr. DiGiacomo that if it put them on notice, it certainly would have put him on notice, and the statute would have to begin. Would this case have been different if they had not asserted that those 3 documents were key to their to the determination? I'm not sure. But they had the burden of coming forward. They picked the 3 documents that Mr. DiGiacomo was intimately familiar with, and in our view, that kicks the statute of limitations into effect.
So you would
I
say,
thought I understood Mr. Narwhal to say that apart from those 3 documents, there was the deposition of Sumner Redstone.
Edward Redstone.
Or Edward Redstone, in which Edward said certain things that would have supplied additional information that contradicted
Right.
what Attorney DiGiacomo had
Right.
represented.
And in response to that, I would say that Mr. DiGiacomo was fully familiar with what happened in 1972 because he represented Edward Redstone in that transaction.
He left, I was going to ask Mr. Castleman, he was independent, but he left.
This was
No.
well before he was appointed, Your Honor. This was in 1972. He was appointed
Okay.
independent counsel in 82.
Okay.
But so anything that Mr. Redstone testified to about his state of mind or whatever in 1972 was something that Mr. James DiGiacomo was intimately familiar with when he became the trustee. He knew all about the 72 transaction. And the plaintiff would suggest that the level of his prior involvement and somehow presents some kind of a conflict, so it would take him out of the Demoulas decision. That's not, as I read, what the Demoulas decision says. The Demoulas decision, when it used the phrase involved and cites other cases, is talking about a trustee who was an aider and abettor, if you will, was party to the fraud that the plaintiff's claim is at issue here. No one in this case has suggested that Mr. DiGiacomo colluded with Sumner Redstone or Edward Redstone in any respect as far as this transaction was concerned.
could I ask
Mr.
one more?
Keating? I'm sorry, can I? Maybe this goes to the merits, not the statute of limitations issue, but it may relate in some respects. This 1983, I guess, financial statement
Yes.
that we've just heard about that suggests there's $100 million of net value
Right.
at a minimum.
Right.
Is that information new information? Is it a question of that information being evaluated differently by different people who are assessing the value of the business, or is there something that jumps off the page that wasn't disclosed?
I don't think anything jumps off the page about it. There's a footnote in our brief where we talk about that information or similar information. We point out that actually there was a huge liability that went along with a statement that they had so much real estate and whatever. I mean, I think the problem here is you're looking back at a transaction that occurred 23 or so years ago. Anybody can take a look at a transaction to value stock in a privately held corporation that took place 2 weeks ago, and you could find ways of sharpshooting it. And I think that's what's going on in this case. This case is a very hard case to defend. Witnesses are dead. Documents are unavailable. Mr. DiGiacomo's documents are unavailable. The Citibank documents have been discarded. The witnesses that are alive have fading memories. So while you have the statute of limitations.
Can I just interrupt that peroration for 1 second? The question, I just want to see if I get your argument on the grandchildren's trust and the lack of the GAL. Is it that, look, the beneficiaries, the 4 grandchildren, were the same people that Mr. DiGiacomo was required to be representing as independent counsel? So it's really form over substance to talk about that as a different thing?
That's partially correct. I mean, that is part of our argument. There's other parts of the argument, too. When he valued Michael and Ruth Ann's shares, he knew he was valuing them for the grandchildren's trust as well as for the 1972 trust. There's no question about that. So he sort of assumed a fiduciary role towards them in that regard. He also, because it was deemed to be in the best interest of Brent and Sherry to have their shares redeemed, he also, I would suggest, took a fiduciary responsibility towards valuing their shares, which were the same value as Michael and Ruth Ann's, because he knew they were going to be redeemed. And thereafter, it is our view, Your Honor, once again looking at Demoulas, that if he, as trustee of the 72 trust, perceived that there was a basis for him to bring a claim to recover for for Michael and Ruth Ann, it would have been incumbent upon him, either because he had fiduciary duties to Brent and Sherry, or because he's an attorney and he knew there had been a wrong, he might have ethical duties to pursue that as well. So we think the fact that he was not nominally a trustee of the Grandchildren's Trust for statute of limitations purposes is not an important distinction.
Thank you, Mr. Keating.
Thank you, Your Honor.
Mr. Castleman?
May it please the Court, my name is Howard Castleman, appearing on behalf of the defendant, Appellee Edward Redstone. The statute of limitations does and must protect former trustees and other third parties from ancient claims. In the present case, as Mr. Keating said so eloquently, the 1972 and the 1984 redemptions occurred over 20 and 30 years ago. Records are gone, memories have faded, witnesses have died. The maintenance of such ancient claims, unreasonable for all the defendants here, is particularly unreasonable with respect to Edward Redstone, who for the last 36 years, since 1972 and during the 1984 redemption, had no connection to these Redstone family trusts or national amusements, not as a trustee, a beneficiary, stockholder, officer, or director. No connection for 36 years. In granting summary judgment for the defendants, the trial judge properly applied the statute of limitations to an action brought decades after these stock redemptions by a new trustee and a single beneficiary. The lone beneficiary is Michael Redstone, who is not joined by his cousins. He is exhibiting a dramatic case of seller's remorse, seeking through advancing the stale claims to have the Massachusetts courts deliver up one half of what is now an $8 billion company, the fantastic growth of which occurred well after the 1972 and the 1984 redemptions.
So the claim against your client really relates to a breach of, alleged breach of fiduciary duty in connection with the 1972 settlement agreement?
That is correct, Your Honor. There's some language in the trust, though vague, which might apply to the 1984 redemption, but the focus appears to be with respect to the 1972 transaction. As was recognized earlier by Justice, I think by a number of the justices, the oral trust was a disputed fact. The record on summary judgment is clear.
The oral trust was a disputed fact back in 1972?
Correct. Mr. Giacomo testified at length that through most of the negotiations, which lasted many, many months in 1972, with Mr. DiGiacomo being adverse to Sumner as Edward's attorney, for many months there was negotiations about 100 shares. Towards the end, the record appendix shows that the concept of a oral trust was sort of sprung on the negotiations. And as an attempt to settle, Mickey Redstone was saying there are 50 shares that must go in the grandchildren's trust. And Edward said, I've never heard of an oral trust. There is no oral trust. There was a compromise. That compromise was embodied in a settlement agreement. The settlement agreement made references to an oral trust, and a difficulty aspect of this case is that the oral trust, the settlement agreement says, I, Edward Redstone, having been an oral trustee.
So the terms of the oral trust, I take it, your point is that the terms of the oral trust were resolved in the 1972 settlement agreement.
They were
Dispute of the terms of the oral trust were resolved in the 1972 settlement agreement.
the dispute was resolved. I would not say that that meant that there had ever been an oral trust.
No, we understand.
But the dispute was
The
resolved
fact
by,
that the dispute as to
by
whether
taking
one-
the position that for purposes of the family, we will say that there had been a trust and we are now creating a written trust and certain shares were put in trust. Mr. DiGiacomo knew very well all the terms of the 1972 agreement, and when he was a trustee in 1984, he was the person, as Justice Botsford referred to with the Demoulas standard, the person who was in power, who had the knowledge to bring an action on behalf of the beneficiaries. Mr. DiGiacomo testified during his deposition that he had no conflict. He was burdened by no conflict. And he said, and I'm quoting from his deposition, the question was, and would you have been affected in any way by your prior relationship to the Redstones, or by your relationship as the former independent counsel, or your role as counsel to Edward Redstone, or in any fact, any business relationships that you may have had during this time with Edward Redstone? Answered by Mr. DiGiacomo, in my view, I would not. But if I felt that I would have been, I would have resigned, reported the matter to the court, and suggested that the court appoint the trustee to pursue the litigation. This is exactly what a fiduciary, whether it's a trustee or an independent counsel who has fiduciary obligations, can and must do. Mr. DiGiacomo was not burdened by a conflict because he had the avenue available to him, and he testified that he would take it. Also, during the deposition, he made clear, as Mr. Keating referred—
Mr. Castleman, I know we've let people run over, but that is actually in response to Justice's question, so would you just wrap up your argument? Thank you.
Sure, Your Honor. Thank you. The unbounded actual knowledge of the beneficiary standard suggested by the plaintiffs is not and cannot be the law of the Commonwealth. Under such a legal theory, the statute of limitations would never run against a former trustee, not after 10, 20, 50, or even 150 years, as long as there was a contingent beneficiary that was willing to advance a purported claim which no experienced and reputable trustee with knowledge had previously saw fit to advance in a timely manner.
Thank you, Mr.
Thank you.
Castleman.